Good morning, everyone. Welcome to the Economic Matters Committee. Today, oh, is it afternoon? What did I say? Morning? Good afternoon, my bad. It's Wednesday, February 18th, 1 p.m. We have a short docket this afternoon, which, by the way, apparently I have a bill hearing as well. With that said, for anyone that is here before us that is new to the committee, except for the legislators who are presenting their bills, if you are going to be presenting testimony, you are allotted 2 minutes. You will be clocked and timed. If the timer catches you, we would respectfully request that you summarize your testimony and not read through your next several sheets, just in the interest of time. If you have provided written testimony, it will be reviewed by the members. With that said, we can begin, and we will begin with House Bill 643, which is my bill. So I will come before you, and Vice Chair, you can preside over this next bill. Okay. I'm sorry,
Madam Chair, would you like to bring up your panel?
Yes, I'll bring my panel up. Good afternoon, members. For the record, Delegate Chris Valderrama here, presenting House Bill 643. I will preface by saying to the members, no questions, please, if you want your bills passed in this committee. That was a joke, kind of, sort of. Delegate Ahrens, thank you for turning your light off. With that said, it's a very simple bill. It's an expansion of a bill that I presented maybe last year or 2 years ago. Really all it does, it's responding to a well-documented workforce, the CPAs. There is a shortage in the accounting field, profession, and what this bill would do would modernize Maryland CPA licensure pathways and in a targeted and responsible way. So the bill would preserve all safeguards, including the CPA exam, supervision requirements, and current pathways, while adding a structured and experience-based option. So I'm sure everyone can attest that in these days with trying to get a job and a career, that experience does count for a lot. I think last year the bill had modified educational requirements, additional requirements. So this is just another way to enhance that bill from last year. And so I have my panel with me. Madam Vice Chair. Thank you.
Thank you, Madam Vice Chair. My name is Nick Manis here representing the Maryland Association of Certified Public Accountants. With me is Rebecca Olson, who's the CEO of MACPAs, and we're here in support of House Bill 643, CPA licensure. I'd like to thank the committee chair for sponsoring the bill and the two co-sponsors, Delegate Chi, and Delegate Wyville. You know, you've been down here a long time when you passed a bill 33 years ago to require a 150-hour requirement, and now you're here saying we don't need the 150-hour requirement anymore, so it's probably time for me to leave. But with that, matter of fact, the chairman of the committee of that for Economic Matters at that time was Cass Taylor, who, of course, this building is named after now. In a nutshell, what this bill would do, currently there's a 150-hour, which is an extra year of undergraduate requirement for CPAs. It would allow the individual to work in a CPA firm and gain experience. So the requirement would have to be approved by the Board of Accountancy. So instead of 5 years of continuing ed, they could get out as an undergraduate and then work for a CPA firm, and that would qualify them to sit for the CPA exam. We know of no opposition. The Board of Accountancy is for the bill, and with that, I'll turn it over to Rebecca.
Good afternoon. Thank you to Delegate Valderrama for bringing this important piece of legislation for our profession, and for Delegate Chi and Wyville for co-sponsoring. As Nick mentioned, my name is Rebecca Olson. I am the CEO of the Maryland Association of CPAs, founded 125 years ago with nearly 8,500 members throughout the state, here in support of HB 643, which would modernize CPA licensure while preserving the rigor and public trust that the CPA is known for. Our challenge is that our current licensure model is a one-size-fits-all, and it doesn't really reflect today's professionals. So rising education costs and the growing demand for accounting and finance talent has really led to a shortage. What this bill would do would to keep that existing pathway, but add this experience-based pathway as well. This will reduce unnecessary barriers and really open up licensure to a more diverse population. This maintains the rigor and the public trust through the CPA exam and oversight by the Board of Accountancy, which you should have a letter of support from as well. Importantly, though, this is also a competitiveness issue. 15 other states have already passed and implemented such a pathway, including our neighbors in Virginia and Pennsylvania, and 25 other states have passed legislation, dozens more working on it right now. So the bottom line is HB 643 supports Maryland's workforce, supports economic growth, and makes sure that Maryland maintains its competitiveness. So I request a favorable report on HB 643. Thank you.
And I knew you guys would hit your lights the way you did. I will say, I will also add, Madam Vice Chair, that the cross-file of this bill is the chair of EEE, who is a CPA, so he is mindful of who is opposing this bill, if any. Just putting it out there, and we urge a favorable report of House Bill 643.
Okay, thank you for your testimony. Are any of these lights for real? Delegate Queen, is your light for real? Okay, go ahead.
There you go, Nick.
Thank you. So since I'm a professor who teaches in accounting and finance, how have the schools felt about this change?
Yeah,
sure. The educators have been in support of this. This is actually something that we've seen. Of course, there's reasonable concern about the Masters of Accounting programs. What we've seen is that really what people were doing with that additional education wasn't master's programs. The people that are going after the master's degree, they're doing it because they understand the importance and they want that additional education and that prestige. The students that were getting their additional hours, which is still an option, still the pathway through that, were really using it to just put in other minors and things like that. And so it wasn't really creating a better profession necessarily as it was intended. So this gives that option if they want the additional education through a master's degree, which we believe is really important and well as well, but gives that option for if those have lots of years of experience but have been left out of the profession or licensure just because of cost and time that it takes for those additional hours.
Sure. Delegate Weibel.
Thank you, Madam Vice Chair. I had a young man in my office yesterday, an accounting major at Mount St. Mary's, was totally unaware that this was out there, but was excited that this bill was before us and eliminating the requirement. So I just want to thank you all for bringing the bill.
Absolutely. We hear that from students a lot.
Bonus points, Delegate Weibel, bonus points. I'm keeping
That his
track.
name was on there. Okay. Any other questions or compliments for the chair? All right, we have one more person in testimony. Is Betty Knowles, Coles Steeman coming? Is that, oh, here she is, okay.
Thank you for the opportunity for me to also present testimony on this. I represent the Maryland Society of Accounting and Tax Professionals. We do a lot of work with MACPA and totally support their position as well as they support ours because they actually happen to be the same position. I was asked by MSATP to talk about this issue because I'm old. I've been practicing accounting for 50 years. And when I looked at the bill, I realized that what you're trying to bring in is exactly what I had to do 50 years ago in college. It was the same requirements, 120 hours, 2 years of work, but the degree had to be in accounting. That was the big difference. But it does make a big difference as well. It's important to understand that the 150 hours has really killed our pipeline for potential workers because they look at it and they go, well, why do we have to do 5 years? Nobody else is doing 5 years. And from a cost standpoint, of course, that's a huge item as well. So I really think that this bill takes me back to where we were 50 years ago. The pipeline was full. We didn't have problems finding workers. They were there. And this should help all of us help hire people as well. I also think it's going to be a benefit for the small firms because when you've got a 5-year degree, they want more money. And a small firm may or may not be able to pay that. Doesn't mean that the person knows less, it's just that the resources are not there. So I think from that standpoint, it also helps both large firms and small firms. I also think that one other piece is that it's important that the new CPAs are able to use their knowledge, and not just from a book standpoint, but what does it mean in the real world? That has always been a concern of mine. I've seen it. I also do some teaching. So to summarize, I support this bill. Our society supports this bill. We support MACPA and also supporting it. And thank you again for your time.
Thank you for your testimony. I don't see any questions. Thank you for coming before us. Seeing no other witnesses, that concludes the bill hearing on House Bill 643. We'll now move on to House Bill 618. Delegate Johnson, AKA Big Storage, for self-storage storage facilities alterations.
Good afternoon, Madam Chair, Vice Chair, members of the committee, and for the record, my name is Delegate Andre Johnson, AKA Big Storage. And Madam Chair, before I start, I just want to let you know that I took heed to your words, and I didn't turn on my lights, so I'm just letting you know that I didn't turn on my lights, so this bill should go pretty good, right? So HB 618, this is a very, very simple bill. So it's making targeted changes to how self-storage units are operated legally. There's 3 main tenets to the bill. One is making agreements, aka electronic agreements, valid alongside paper agreements. It also allows operators to give tenants 30-day notices after a non-renewal is given to the tenant to remove their items from their storage unit. The third tenet of it is it also allows the operator to dispose of the remaining items that are left in the storage unit only after the operator gives them an additional 10-day notice of disposal of their property, if they haven't disposed of their property. This bill has no effect on the state, no effect on local government. It's cross-filed bipartisanly. Senator Jackson and Senator Hershey. The AG's office is good with the bill. And so for all those reasons, I ask for a favorable report. I'll turn it over to my panel.
Madam Chair, Madam Vice Chair, members of the committee, my name is Daniel Bryant. I'm legal and legislative counsel to the National Self-Storage Association based in Alexandria, Virginia. Thank you for the opportunity to testify today. As for your support for House Bill 618, a bill meant to modernize the Self-Storage Act to provide a remedy when the owner or occupant elects not to renew the rental agreement and property is left behind. As the delegate just mentioned, this bill was negotiated and language is ultimately agreed upon with the Office of Attorney General Consumer Protection Division. Thank you to Assistant Attorneys General Sakamoto Wengel and Stroud for their collaboration on this. Additionally, Delaware, California, Pennsylvania, Tennessee, Maine, and Illinois have substantively identical provisions currently in their respective storage acts. And just this past week, the Virginia Senate just approved a substantively similar bill unanimously, both from the committee and on the floor as well. And with that, I respectfully request your support for passage. And thank you again for the opportunity to testify, and I'd certainly be happy to answer any questions.
Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. For the record, Bruce Veriano with the Self-Storage Association of Maryland. You've heard the testimony. I would just say for the first time that I can remember, me too.
Wow. What? Okay. I don't see any questions.
No Yiddish today, no nothing, no.
Oh, we have a question, Delegate Queen.
Thank you, Madam Chair. Actually, I do have a list of questions, but I think I want to talk to the sponsor offline. I did get some questions people wanted clarification on.
Okay.
Okay, thank you.
Thank you.
Are you sure you don't want to at least ask one, Delegate Queen? You don't want to ask any? Okay. Delegate Chi.
Thank you, Madam Chair, and thank you for presenting the bill. So I recall something similar being introduced, but looks like the fiscal note says there has not been a similar bill.
This,
Refresh our.
these proposed changes, and I've been, with them, have not been presented to the legislature previously. They have not.
Okay.
We've had previous legislation in this committee, as you're aware. You've been very, very helpful and supported it, but they dealt with other aspects of the current law, modernizing it with all consumer protection. As the sponsor said, I'll just say we spent about 3 months back and forth with the Attorney General's office before putting anything in, so to make sure that they were comfortable and supportive of it. Thank you.
Thank you.
You see, Big Sturge, you have so many bills. Delegate Chi thinks we already moved this on this bill. There are no further questions. Thank you very much.
Thank you all very much.
There are no other witnesses. This concludes the bill hearing on House Bill 618. We'll now move on to House Bill 716. Delegate Pippy.
Run down to another committee. Thank you for being here.
Do you have a panel, Delegate Pippy?
I do not.
Okay.
Good. Colleagues, Delegate Pippy, for the record, here in support of HB 716. So I'll give you a little gist of the background, and then I'll give you what the bill does. So this bill pertains to surveyors on private property. We had a situation in Frederick and in Carroll County where surveyors for a power line were entering private property during hunting season, and it posed an issue to where a federal judge had to kind of weigh in and try to come up with some sort of compromise. So what I'm hoping with this bill is that it clarifies what is going to happen forward. So this bill would actually say that during deer firearms season, which is approximately 2 weeks from late November to mid-December, that a surveyor cannot enter private property without a signature from the written permission from the property owner. And you can look at it 2 ways. You can look at it, one, from the lens of safety. You have people hunting on their own property with a license, and they have firearms, and they're hunting, and there's a safety consideration there. The second piece is property rights. So you absolutely have a right to a hunt, if you get a license, and then you absolutely have a right to be on your own personal private property. And the problem is that the way the laws are written in Maryland is that if you're a surveyor for, let's say, like a utility, in this case, you can kind of infringe on those rights. So there's been some recent legislation that was passed. And so what I'm hoping is that this clears it up. It's a narrow window. It's a narrow thing. We certainly appreciate surveyors and their professionalism. They have a job to do. But I represent Frederick County. It's a big hunting district. Deer season's very important. Property rights are very important. And I think this kind of sets it straight that, look, when it's hunting season and someone's legally hunting on their own property, you cannot have strangers walking around in the woods for the purposes of maybe surveying for eminent domain, of all reasons. So I think this is a fair compromise. I ask this committee for a fair shot in your consideration. And happy to answer any questions.
I don't see any questions, Delegate Pippy.
Okay.
Oh, we have one. Delegate Weigel and Delegate Rose.
So, Delegate, you talked about private property rights. I'm wondering why So outside of deer season, so you're telling me a surveyor has the right just to enter onto someone's property without permission?
They do, in narrow exceptions, yes. And what happens too, to muddy the waters, so to not get into legal discussion, but trespassing is trespassing, right? But if you're a utility surveyor, you're not technically trespassing in some cases. And so I think that's why the issue rose in Carroll County, and a federal judge kind of had to weigh in to say, hey, look, we got to have some sort of balance here, because you got people in the woods hunting. You got surveyors trying to survey for this power line project. What's the right thing to do here? And so what I tried to do with this bill was to say, for the 2 weeks, deer rifle season, that you just got to get permission, and hopefully it won't be an issue for most people. But otherwise, you could have a scenario in which private surveyors for a private company like PSEG are in the woods walking around during hunting season when people are hunting on their own property legally. And I just think that's too much of a conflict to have.
And the bill prohibits any surveyor, not just utility surveyors?
Yes.
Okay, thanks.
Delegate Rose and then Delegate Howard.
Thank you, Madam Chair, and thank you very much for the bill. And would you say it's very important, especially for a lot of folks that live in Carroll and Frederick, certainly other places as well, but there's a lot of people that rely on the deer hunting that goes on in that 2 weeks to fill their freezers and feed their families. That's traditionally what they do, and it's kind of a very necessary activity for them.
It is, and I'll just say this may be foreign to the Economic Matters Committee, but for a lot of people in Maryland and across the country who live below the poverty line, hunting is actually an important thing for their families. It's, provides sustenance in many cases. So we have some property in West Virginia. People hunt, they fill their freezer, and that feeds them for a year. I mean, that's actually a big deal. That seems like a foreign concept to a lot of folks here, I know, but for a lot of places, that's a very real thing. And so the idea that, in a very narrow example, a private company out of state can prevent you from hunting on your own property, during hunting season when you have a license is just shocking to me. So open to suggestions on amendments, to narrow it down, because Delegate Weibel asked a good question. Would this apply to all surveyors? Could we narrow that down? I'm open to any suggestion you guys have.
Delegate Howard and then Delegate Ampry.
Thank you, Madam Chair. So the state of Maryland is a large equestrian state, and we've done a lot in the state of Maryland to accommodate for that, and including Sunday hunting bills. So I just wanted to get a sense, if you wanted to add anything about the parity that I think that this would bring. We do those bills because of safety reasons, the same things that you're citing here. And I just wanted to get your sense. Have you looked into that? Because it does seem like a little bit of a parity issue to me as well as a safety issue. So I didn't know if you had
Well, sure. So that's a great example, and I do recall that in many jurisdictions in Maryland that they've adjusted certain types of hunting thing to avoid the scenario in which a hunter shoots somebody who's enjoying their equestrian rights, so to speak. And so, look, I may have different motives for this bill, but a safety factor is a big thing, right? Because you have people walking around in the woods during hunting season like I'm walking on your property, so it's your property, you're hunting on your own property with your kids, and I'm walking around there, and I think that poses a real safety concern and should be part of the equation, so I appreciate that. Mm-hmm.
Delegate Ampry.
Thank you, Madam Chair. And I have a couple of questions, but we can have some conversation offline. I just wanted to get a sense of how frequent, is there any data to show that there's been any accidents or situations where people have been harmed by hunters while they're surveying? And I imagine when the surveying happening, there's some type of notice given out. I just want to understand, what does it look like in practice, and how often are we seeing dangerous situations happening?
So it's a great question. I think there's going to be an increase in prevalence to that, and I'll tell you why. Because look, the energy policies in the state have put us in a situation where there are going to be more power lines coming to Maryland, unfortunately, including this project in hand, and that's going to require more surveys. And so the more surveys, the more projects coming to Maryland, the more surveys needed, the more surveyors in the woods. And we had a meeting with PJM, and they basically said there's There's no short-term solutions. The only short-term solution is we need more power lines. And those are coming to the Eastern Shore. They're coming, another big project's coming to Western Maryland. You got the existing project that goes from Baltimore to Carroll to Frederick. And so what comes with that is you have more surveyors in the woods. Every year there are deaths related to hunting, accidental deaths. You can look that up. I think it's 6 point something per year, something like that. But I would argue that, you know, the more surveyors you're putting in the woods, the more opportunity there is for an accident to happen. I'm proud to represent Frederick, which I believe has the highest concentration of hunters in the state. And I know Carroll County has a lot of those too. So I just think that we need to strike a balance. I'm certainly willing to consider any amendment that if the surveyors have some suggestions on to make this more workable for them. Look, they're professionals. We don't want to do anything that binds them up either. But I think this is an issue that needs to be addressed. And I got to tell you, the idea that you just cancel hunting season is not an option. And I think that's completely unjust and unfair, and that a company can say, hey, we're surveying for these 2 weeks. Sorry, you can hunt next year. I think that's not fair. I don't think that's a reasonable compromise. So I'm hoping that this committee can figure something out.
Thank you, Delegate Pepe. There are no further questions.
Thank you.
I want to be on the record, on camera. I'm about to call the unfavorables. So if it's someone on this committee or if it's someone watching, I may be a new chair, but I'm no rookie. So whoever signed up as move fund 5 variable, as in move unfavorable, you're not catching me on that one. So whoever's watching or listening, you will not be called.
Yeah.
With that said, but nice try, whoever tried
like
to
that.
catch
That's
me on that. We have our unfavorable testimony. We have Bill Kress and William Bauer.
Madam Chair, Madam Vice Chair, committee members, good afternoon. I'm Bill Bauer. I'm a licensed professional land surveyor and civil engineer. I represent the Maryland Society of Surveyors in opposition to House Bill 716. Land surveyors, by nature, are outdoorsmen. We spend our days outside locating property markers and physical and environmental features. Many surveyors are hunters. I am an avid fisherman. We got into this profession because we love being outdoors. We protect the public with accurate locations of property boundaries. However, we also see America's aging infrastructure around us. Our infrastructure is showing its age, and difficult decisions need to be made about how to fix it. Restricting surveyors from helping to determine the best and most cost-effective route for infrastructure improvements is not in the public's best interest. How will this bill affect current and future SHA road projects or county water and sewer projects? Additionally, this bill applies statewide. There is no provision for surveyors working in urban or suburban areas where no deer hunting occurs. The bill simply places a broad restriction on surveyors that imposes a moratorium on routine survey practices that would damage the real estate and construction industries. And finally, there is no data showing that surveyors are being injured by hunters in Maryland. The Maryland Society of Surveyors respectfully requests an unfavorable report to House Bill 716. Thank you.
Thank you, Madam Chair, members of the committee. My name is William Kress. I'm here today on behalf of the Maryland Society of Surveyors in opposition. I appreciate the sponsor taking time to meet with me to discuss the bill. So there's always been a balance between property rights and the rights of surveyors to enter onto property for surveys. This bill would require written notification, which presumably would mean a certified letter. Perhaps you might not think that's too much of an ask, but we have properties where it's difficult to identify the owners. The owners might be out of state. But more importantly, on the way the bill is drafted, it focuses on firearm seasons for deer. And that, by my research, is from October 16th to 18th, November 15th to the 16th, November 29th to December 13th, and then again January 9th to the 11th. That would shut down surveying practically in the state because of the owner's requirement of written notification. I want you to think more beyond the power lines. Think about home closings. building fences, building additions. This bill would have a dramatic impact on commerce in the state. Perhaps there are ways to work around this with amendments to try to give some relief. I understand that there are constituents in those counties with the power lines have raised concerns about that, and I know there's ongoing litigation. There was litigation around that issue. So with that, I would ask you to take a careful look at this. Think about the historical perspective that the state has waived those rights and allowed surveyors to go into properties. And Mr. Bauer would know better than I, but oftentimes when you're doing a line survey, you have to enter onto 3, 4, 5 different properties to find the markers. So that's 5 properties you have to notify. And it's onerous on the profession. Thank you, Madam Chair.
Thank you. We'll start with Delegate Rose, and then Delegate Howard, and then Delegate Weigel, and then Delegate Pippy.
Thank you, Madam Chair. So we're talking about 2 weeks for hunting, correct?
The way the bill is drafted, it says firearm season. So there are multiple firearm seasons.
Well, the main firearm season. So are you offering amendments?
I'm just pointing out that the bill is much wider.
Okay, I'm just asking, are you bringing amendments?
We're happy to discuss amendments with the sponsor.
Okay. Secondly, when you mention builders, closings, doing home improvements and things like that, having been through those processes many times, that's something that's scheduled. So there is notice. There is discussion with the property owner. So you're kind of not comparing apples to apples to me. I mean, this is a different situation where we have people, usually they work around that. But when you have, in this particular instance, a company that is rather hostile to, the communities that they are encroaching upon, that really brings a problem. And when you are told that you can't hunt on your own property, I think that's getting to be a little bit ridiculous. At BG&E, we had a similar situation when they had to do something in Carroll County, and they did provide notice, and they worked with the local landowners. But before that happened, there was a lot of calls to local government officials and said, "Why are there people on my property? What is going on? How come? Why are people walking around with surveying equipment?" So I think that this is reasonable because it's so narrow. I think it's certainly fair to make sure that these communities that really do rely on hunting are able to do so and not have to worry about this kind of situation happening. So I very much appreciate the legislation, and I think it's extremely important for those communities.
I'll just respond by saying I appreciate where you're coming from. I know you have constituents that are concerned about that. With respect to closing down hunting season, that's certainly nothing that happens per statute. That may be something that happened within the litigation. I'm not familiar up to speed with that. I know that there was a recent court case, and there was some resolution that was issued by the court, but that is not something that would occur based upon the surveying statute and how we operate day to day. And to be fair, and I think it's probably not the intent of the sponsor, but there are multiple days and weeks that are affected because of the deer seasons.
But isn't it so that as lawmakers here, elected lawmakers, when something happens, that there's a court case that maybe is bringing up something that's a problem, wouldn't it be logical for us to bring that forward and say, this is something that needs to be fixed moving forward?
Absolutely prerogative of the committee. I'm just saying that we're not shutting down deer season or hunting season through our practices. That if that happened through the court system, that may be, and that may be just limited to the power lines. But that's not a function of the current statute.
Yeah, I just think that doing this is not going to hurt to make it very clear moving forward so we don't have to go down that road again because there's clear lines in the law. So
appreciate that.
Thank you, Madam Chair.
Thank you, Madam Chair. So I would just say this. So in the fiscal policy note, it says this bill prohibits a land surveyor or a property line surveyor from conducting a survey on private property during deer firearms hunting season without, so it's 2 parts, the written permission of the property owner. So based on the size of the property, I think what the sponsor is getting at is rifle season. What you're talking about in multiple firearm seasons is also black powder. So you may have a property owner who, because of the size of the property, allows for black powder but not rifle because of the range of the weapon, quite frankly. The reason I know that is because in Anne Arundel County, you are not allowed to discharge a firearm inside of 100 yards from a dwelling other than your own. That used to be 150 yards. We lowered it to 100. So it comes based on two parts. And the second part, and I think it's the most critical part, it says written permission of the property owner. So you may have a property owner that only hunts rifle, which is 2 weeks. You may have a property owner that only hunts black powder. Fact of the matter is that the surveyor would still be able to do the survey just upon written permission. Hunters get written permission to hunt on properties all the time. It's not a certified letter. It's just literally a piece of paper that you carry around with your hunting license. I mean, I've hunted Alaska, Canada, North Carolina, the Midwest. I've hunted all over the earth, quite frankly, and it's pretty much the same anywhere you go, even in other countries. You just carry a written permission slip with you to be on the property during that time. So I'm failing to see, quite frankly, how there's 52 weeks, right? How 50 weeks a year isn't enough. And disturbing a hunt is a violation of state law. And that's effectively, not in a malicious sense, but that's effectively what a surveyor could be doing while walking around on property.
May I respond?
Please.
Thank you, Delegate. Thank you for the question. So I haven't deer hunted in a long time, but it's my understanding that there's a junior deer season, firearm season. There's a secondary season, the 15th to the 16th. There's a season, the 29th through December 13th. Then there's a second winter firearm season, January 9th through the 11th. So again, it's drafted much more broadly than 2 weeks. But beyond that, if you want to do a property survey of your property, let's say you're going to closing, and you have 5 adjoining properties, it's not unusual for the surveyor to have to go on those properties to find the locations and markers.
Well, you just gotta go
so you have to have 5 written permissions to go out and do that survey.
We make state law so that we can track wounded game to protect a hunter because they have to go on other properties, right? So that's not the case here. Why can't they just go get the written permission?
I think it's going to be cumbersome. It's a statewide bill. And if you need multiple permissions from multiple adjoining properties, you're going to be shut down through deer season.
But we make hunters do that. So if I'm hunting even an adjoining property, I have to go and get written permission. These farms might be contingent, or they might be touching each other, right, property-wise. But I have to go get 5 different permission slips. I don't just get to go on one unless I shoot an animal and it jumps a fence and I rightfully am protected under state law by going after that animal. But to actually hunt, even on a contingent property, I have to just get a written permission slip, which is literally just knocking on the door and asking the person.
So I would just make the distinction, and it may not be the case with the power lines, but typically a surveyor is going onto a property because that property owner has asked them to come on to survey.
Okay, so they would have written permission.
But they still have to deal with the adjoining landowners.
So they just go get written permission, just like anybody else that would enter the property for legal hunting.
That is certainly a possibility. I just want to raise that issue to the committee.
But that's not, and I'm not trying to be, that's not the possibility. That's literally how we handle it in state law. If you don't have written permission, you're hunting illegally. I mean, I can tell you, if a DNR officer makes contact with you, they want to see how many rounds you have in your gun. They want your license, and they want the permission. That's it. Period.
All righty.
Isn't that so? Thank you, Madam Chair.
Thank you, Madam Chair. I want to make sure I'm clear on this because you seem to indicate it's a concern about notifying property owners, but our fiscal note under current law, access to private property, says civil engineers, land surveyors, real estate appraisers, and their assistants working on behalf of the state, its instrumentalities, or any specified body having the power of eminent domain may may, after making every real and bona fide effort to notify an owner or occupant in writing, enter the land to make surveys, set stakes, et cetera. So it's already current law that you're required to notify those landowners in writing. Is that not correct?
Well, it is correct if you're a government surveyor. So if you're employed by a governmental subdivision, excuse me, that is correct in eminent domain cases. For the professional surveyor that's doing the typical boundary line surveys, that's not required.
So if this bill were modified to include those specific instances, you'd be okay with it?
I'm sorry, say that again?
If this bill were modified, it didn't apply to all surveys, but applied to the state, its instrumentalities, or anybody having the power of eminent domain, you'd be okay?
I think that is the current law, if I'm not mistaken.
Well, there's a difference in notification versus permission, correct?
That's fair, yep.
Yeah, so I think the bill addresses permission, whereas current law addresses notification.
I don't represent the government or their surveyors, so.
So your surveyors don't do work for government entities?
Yeah, we do projects for like Maryland State Highway Administration.
Okay.
And we send out letters by certified mail to all the affected property owners.
I mean, I think the bill sponsor's intent was to address those that have eminent domain. So if the language was further restricted in seeking permission or granting permission, would you be okay with that language or not? Or you still would be opposed to the bill if it?
Or do you mean within eminent domain cases?
Yes.
Private property or private surveyors generally aren't involved in the eminent domain portion of it.
So private surveyors don't work for utilities?
Yes, they do.
And they have eminent domain?
Okay. We would have to see what the amendment was.
Okay. All right. Thank you.
Great. So this is a good conversation, and I will just tell you that it's helpful to have it because I think one amendment that I'm going to propose is that it would only apply to the property in which you're actually hunting on. So it's that way it's not as broad as it would apply to all private property in an entire county. So I think the intent, subject to the person who drafted the bill, would be that it would only apply to the actual property you're hunting on. So it wouldn't apply to the 3 parcels that the surveyor had to walk across to get to that property. It would only apply to the property in which the hunter was hunting on. So the surveyor would only need permission from the property in which the hunter was hunting on. That is completely different than what you were describing. Is that fair to say? You raised the concern that it would apply to all private property during hunting season period.
Right, correct. Yes.
So I guess, would it be better if it only applied to the private property the hunter was hunting on?
That would
Procedurally, I'm not really sure how that would function. How are we going to know that the homeowner's intending to hunt deer during that time frame?
Because it's, all right, well, here's the deal. Look, I'm trying to be.
No, I understand where you're going.
I'm just. I certainly don't need your permission to put an amendment, right? I don't need your vote for it either. But my point is we're going to intend to narrow this down to where it would only apply to the private property in which you're hunting on. That's point 1. Point 2, we'll probably put an amendment to narrow it just to the November 29th through the December 13th, which is the prime deer rifle season, 2 weeks. So you get 50 weeks. These hunters get 2 weeks. So that's amendment number 2, and then potentially amendment 3 dealing with the eminent domain part. And so my final question, you can choose not to answer it, but would that be more palatable for you folks if we narrowed it down to that very narrow scenario? November, late November to early December, 2 weeks only, and it would say it in there. It would only apply to the private parcel the person is actually hunting on. And remember, because it's illegal to hunt anywhere else, right? So there's that thing. And then the other part may be related just to folks that have the power for the eminent domain. And as we know, private surveyors are working for utility companies in Carroll County related to a project that could have eminent domain because they said it, right? So is that better than what you're seeing now?
Yeah, so thank you.
Okay.
And I was just trying to work through the dynamics of the amendment. We would love to sit down and look at the language and work with you. It would make the bill more palatable.
Perfect. I
Subject to
appreciate
the
that. And
language.
we look forward to it. And we appreciate your professionalism, and we certainly appreciate the professional surveys. And this isn't directed at you guys. It's directed at a bigger issue. So thank you. Thank you, Madam Chair.
Great.
Seeing no further questions, thank you very much.
Thank you, Madam Chair.
Thank you.
That concludes the testimony. Concludes House Bill 716. We'll now move on to House Bill 557. We welcome our ECM alum, Delegate Harrison. Welcome back.
Thank you, thank you, thank you. And I do not have a panel, I don't think. Oh, I do?
Oh, it looks like you
Okay,
do.
it looks like I do. Well, join me. Well, good afternoon, everyone. To my former colleagues, I do miss you all, and I get accosted in the hallway sometimes about, I shouldn't say accosted, that's probably not the right word, but, you know, harassed in the hallway about not being here, so. But we're all doing the great work for the people of the state of Maryland. Thank you so much for having me, and for those who may not be familiar, this is a bill that I've put in a couple of times, and for those who don't know, it is House Bill 557, which is a occupational licensing and certification predetermination. For the record, I am Andrea Fletcher Harrison, represent Legislative District 24. I will not read my testimony because you do have it in your packet. I just want to refresh and say that this bill really just deals with individuals who have had some contact with the correctional system, who have finished their time, and they want to move on with their lives and perhaps get a certification in some area. And they have to go to a board, and they have to take the coursework, pass a test, in order to get that certification. This bill says they can go to this board, whatever board it is, to ask if their infraction would disqualify them from being eligible for such a license. We're asking for a binding decision on that. Also, hopefully in your packet, there is the amendment that I put forward that we just got it back yesterday, so I'm hoping that you got it. And it excludes the bill excludes several different departments or agencies, and that would include public safety, it includes financial institutions, and the amendment that we put forward exempts the health occupation boards. And I have worked very hard with everyone on this bill over the years, and so much so that after the governor vetoed it last year, I asked him to draft this year's bill. And I met with Secretary Wu, I met with Secretary Sashmani, I have worked with the health occupation boards, and we have come to an agreement, and everyone seems to be on board. The final thing that I want to say, you all were on the floor when I introduced our local community action agency in Prince George's County today. And I was talking with the CEO afterwards, shortly before I came here, and I was talking about this particular bill. At that agency, the community UCAP, they have a homeless shelter. And one of the requirements for individuals to be there and to stay is that they get a job. They have to look for a job. And what she expressed to me was that they have sent people out several times only to find out that those individuals were not eligible for jobs because of their background. And she expressed that this would be an excellent bill because then individuals would know they would be able to go and find out whether or not they would qualify or whether they would be disqualified so that they don't waste their time to do it. And that's what this bill is all about. So I am humbly and respectfully asking for a favorable report from this wonderful Economic Matters Committee. Thank you very much.
Thank you. Good afternoon, Chair Valderrama, Vice Chair Charkoudian, and members of the Economic Matters Committee. For the record, my name is John Dove. I serve as the Commissioner for Occupational and Professional Licensing with the Maryland Department of Labor. Today, I am testifying in support of HB 557. Again, I want to give my appreciation for the delegates' leadership and attention to this matter in professional licensing. This legislation reflects a thoughtful effort to ensure our licensing systems are fair and accessible while still maintaining standards necessary to protect the public. From our work, we consistently hear from Marylanders with prior justice system involvement who are unsure about whether their criminal record makes them ineligible for licensure. Many individuals automatically disqualify themselves, even when that is not the case. As a result, qualified and capable Marylanders often never apply, cutting themselves off from professional opportunities before taking the necessary steps to start the process. There's also a second group this bill meaningfully reaches: individuals who apply, invest time and financial resources into training or education, only to learn that their records prevents them from license. This outcome is not only discouraging and costly, but also avoidable. By establishing a predetermination process, this bill would provide clarity. Early on, applicants would be able to understand how their records may fare before making investments. This empowers individuals to inform decisions about their careers and promotes transparency through the entirety of the application. Maryland would join other states, Texas, Ohio, Wisconsin, Minnesota, Indiana, North Carolina, Virginia, and the District of Columbia when adopting this approach, demonstrating that it is possible to remove unnecessary barriers while preserving public safety and professional standards. This legislation promotes economic mobility, strengthens our state's workforce, and helps ensure Maryland's licensing systems operate in a way that is fair and effective. With that, I respectfully request a favorable report on HB 557. I'm happy to answer any questions.
Thank you, Mr. Dove. Thank you, Delegate Harrison, for bringing this back to the committee. Just real quick before I take a question, can you repeat the exemptions you made, and then also can you provide a couple examples of potential licenses that folks would be applying for?
Sure. The exemptions are the financial services agencies like, or companies like mortgage industry, financial services that way, public safety, just because of the nature of that particular type of work, and also the health occupation board. So that would be the physicians, the nurses, the pharmacists, acupuncturists. Those professions require so much schooling, which I really didn't have that much of an idea about, with the exception of the ones, the traditional ones. And many of them actually, those schools will do a background check in the first place. So they would know whether or not they would be eligible at that point.
Thank you for doing your due diligence. We'll go to Delegate Weivel.
Thank you, Madam Chair. Just one quick question. What was the reason for the governor's veto?
Well, on sine die last year, and you know how sine die is in the middle of the afternoon, I got a message and it just said, the Department of Health. And I said, just take them out, exempt them. But in doing so, it actually, by removing the Department of Health, it actually undid some of the other language that's already codified. So it would, by taking out the Department of Health, many of those particular, some of the professions in there would be exempt, and it would undo what's already in law.
So this bill is amended to accommodate their request, or is it?
It's just the health occupations.
Okay.
The professional health occupations.
Okay. All right. Thanks.
Seeing no further questions, thank you, Delegate Harrison and Mr. Dove.
Thank you.
We move on to several more favorable witnesses. We have Madeline Del Greco, Courtney Fontaine,
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Madeline Del Greco, and I'm with the Maryland Board of Physicians. House Bill 557 establishes a predetermination process to inform a potential applicant if their criminal history would prevent them from being licensed. Currently, an applicant who applies for a license with the Board of Physicians is required to complete a criminal history records check, and if a criminal conviction is present, the board is often still able to license or license with conditions after consideration of the full facts of the case. It is exceedingly rare that a license is denied based solely on a criminal conviction. The board was concerned that a predetermination process may impair the board's ability to consider the full facts of a case, causing the board to err on the side of caution. The Board of Physicians, along with many other health occupation boards, have been working diligently with Delegate Harrison to support the intent of House Bill 557 while addressing this concern. The board and the delegate worked collaboratively to amend the health occupation boards out of House Bill 557, and the board has agreed to provide more transparency on the current process to ensure potential applicants have a thorough understanding on how criminal convictions may impact licensure. We thank the delegate for her hard work and for her collaboration.
Good afternoon, Chair and members of the committee. My name is Courtney Fontaine, and on behalf of the Institute for Justice, a nonpartisan public interest law firm that works to protect civil and economic liberties, including defending the right of individuals to earn an honest living, I am pleased to submit this testimony in strong support of HB 557. Earning an honest living is one of the best ways to prevent reoffending and promote successful reintegration into society. The Institute for Justice publishes and maintains Barred from Working, a comprehensive national survey of barriers to reentry and the most detailed look at licensing restrictions for individuals with criminal records. It uses 10 criteria to grade all 50 states in the District of Columbia on their legal protections for licensing applicants with criminal histories. While Maryland has taken meaningful steps in recent years to limit overly broad licensing denials, important gaps remain, particularly the lack of a clear and binding premeditation process across key departments. House Bill 557 builds on national best practices by creating a predetermination review process, while also maintaining appropriate public safety safeguards, including exclusions for certain violent offenses and sex offenses requiring registration. By providing this clarity up front, HB 557 gives aspiring workers the information they need to make informed decisions about their futures. Without this process, individuals may invest years of time and thousands of dollars in training, only to learn at the end that a past conviction disqualifies them. That uncertainty discourages rehabilitation and undermines workforce participation. By adopting HB 557, Maryland will align itself with a growing number of states, including our neighbors, Pennsylvania and Virginia, that recognize the importance of removing unnecessary barriers to work while maintaining the appropriate public safety protections. The Institute for Justice urges the committee to support House Bill 557 and ensure that all Marylanders, regardless of their past mistakes, have a fair opportunity to earn a living and support their families. Thank you for your time and consideration.
Thank you, Ms. Del Greco and Ms. Fontaine. Seeing no questions, thank you very much for your testimony. We have one virtual, Mr. David Morgan.
All right, can you guys hear me? Yes, thank you. Yes, thank you. Thank you, Madam Chair and ECM Committee. On behalf of Reason Foundation, as you said, Madam Chair, my name is David Morgan. And there are four things that I would like to highlight that we think that we know 557 would improve about Maryland's current licensing law. One has already been mentioned, which is the predetermination process. Also want to highlight the transparency, mandating departments to explain denials. Ensuring accessibility is also a key point that I would like to point out that deals with capping review fees at $100 and automatic waivers for low-income applicants. And the final thing is restriction on denials, prohibiting licensing boards from denying licenses based solely on convictions of more than 7 years. So those are four ways that 557 would improve the current law. Thank you, Madam Chair and ECM Committee.
Thank you, Mr. Morgan. I have no questions for you, but thank you very much for coming before the committee with your testimony. We appreciate it. Members, seeing there are no other witnesses, that concludes the bill hearing on House Bill 557. We'll now move on to our last bill of the day, House Bill 514, Delegate Rosenberg. Thank you, Delegate Harrison.
Can my panel come up?
Yes, sir.
Please, thank you.
Thank you, Madam Chair and members of the Economic Matters Committee. House Bill 514 would maintain the status quo in Maryland regarding to political activity by 501c3 organizations. Since 1954, when then Senator Lyndon Johnson introduced the so-called Johnson Amendment to the tax law, nonprofits of all stripes have been prohibited from engaging in political activities. The current administration in Washington is proposing to remove this provision from federal law. And the concern is that this would put pressure on nonprofits to engage in political activities and could also become contributions to nonprofits could become a conduit to evade the laws regarding political contributions, because a campaign would be making a contribution to a nonprofit with the understanding that the nonprofit would then engage in political activity. And so this would not be regulated through the campaign process, but would be under 501c3, whatever IRS regulation there would be of that nonprofit. But it's not, but it's outside of the existing process that we have constructed. So what this bill would do, and it is introduced at the request of the Maryland Association of Nonprofits, and we have a representative here from the National Association, is maintain the status quo in Maryland should the federal prohibition regulation be up, the proposed change be upheld by the court system or the Congress. So that's what this bill would do. There are amendments, and I would defer to my colleagues to speak to those amendments. But this bill is cross-filed in the Senate by the Senate President and Senator Kagan. And I would urge a favorable report. Thank you.
Thank you, committee. I'm Carmen Marshall, interim president and CEO of Maryland Nonprofits, a statewide association representing more than 41,000 charitable organizations serving every county in our state. Nonprofits are among the most trusted institutions in American life. They shelter survivors of domestic violence, feed families, care for older adults, protect our waterways, and strengthen neighborhoods. They show up whenever the need is greatest. That trust didn't just happen by accident. For over 70 years, federal law has drawn a clear line between charitable work and partisan political campaigning. That line protects nonprofits from political pressure, protects staff and volunteers from coercion, and keeps charitable resources focused on missions and not elections. Today, that protection is at risk. If federal enforcement is weakened, nonprofits could be pulled into political fights they were never built for. Board seats could become political. Community events could turn into campaign platforms. And organizations that people rely on in vulnerable moments could be drawn into partisan conflict. That would erode trust across communities, no matter your politics. House Bill 514 is a careful Maryland safeguard. It does not create new restrictions. It keeps the same longstanding standard in place only if federal enforcement is rolled back. And it allows for discretion, education, correction, and not automatic punishment. Keeping charities nonpartisan does not silence them. Nonprofits remain free to educate voters, advocate for policy, and engage in civic life. What they cannot and should not do is be used as vehicles for partisan campaigning. That distinction has served our democracy well, and I urge a favorable report. Thank you.
Good afternoon. Thank you for this opportunity to testify. My name is Peter Kirchgraber, and I'm with the National Council of Nonprofits. NCN is the nation's largest network of nonprofit organizations, and we represent more than 37,000 nonprofits across the country, and we strongly support HB 514. Every day, thousands of Marylanders benefit from the work of nonprofits. And all of these nonprofits are free to focus on their missions because for 70-plus years, the federal tax code has protected nonprofits from divisive partisan politics. That protection, known as the Johnson Amendment, is now under threat from some in Congress and the executive branch and from federal courts that could eliminate or weaken the safeguard, starting with houses of worship, leaving all charitable nonprofits vulnerable. Without this protection, nonprofits would face enormous pressure to endorse candidates and to funnel tax-exempt charitable contributions to campaign fundraisers. Donors would rightly wonder, is my donation serving the public good or some private partisan political agenda? Trust in nonprofits would erode. In short, losing protection for nonprofit nonpartisanship would insert partisan rancor and divisiveness into one of the last remaining civic spaces where people of goodwill can still come together, regardless of political differences, to solve shared problems and improve lives in our communities. We should be clear that protecting nonpartisanship is not about silencing voices. Nonprofits can and should speak out on moral, social, and public policy issues that impact their missions. Federal law simply draws the line at endorsing or opposing candidates for public office, and that's a line that protects the independence of nonprofits as well as the ballot box. We strongly feel that Maryland law should do likewise, and a broad spectrum of faith leaders agree. In November of 2025, 182 national organizations signed a letter of support for the Johnson Amendment, including the National Council of Churches, the Alliance of Baptists, the United Methodist Church, the Jewish Council for Public Affairs, the National Council of Jewish Women, the Evangelical Lutheran Church in America, the Black Church Center for Justice and Equality, the Baptist Joint Committee for Religious Liberty, and many, many others. Thank you very much. Be very happy to take your questions.
Thank you, Madam Chair, members of the committee. My name is Henry Bogdan. I'm the Policy Director at Maryland Nonprofits. You've heard the rationale, the concern we have to retain protection of nonpartisanship. It is a real concern. Besides a case pending in Texas on this matter, there are two bills in Congress, as there have been before, that would affect broadly charities. The Texas case deals with religious organizations. President Trump has publicly stated his desire to destroy the Johnson Amendment. So we're here before you asking for the protection. The bill would apply, and that prohibition currently would apply only to 501c3 organizations. It's written into the Secretary of State statute, but not necessarily using all the powers of the Secretary of State. There have been significant amendments drafted in the last week to this bill based on concerns expressed at the Senate hearing by religious organizations. We believe that these should satisfy those and alleviate those concerns. The bill does not prohibit any advocacy that's currently allowed in election year or not. It simply adopts the language of the Johnson Amendment and the IRS guidance as it existed and it was applied as of January of 2025. I would note that while there has been talk that the IRS has changed policy, all of the documents that were there in January of 2025 are still on the IRS website. I attached, for your information, Revenue Ruling 2007-41. It's a nice restatement of the basic rules with hypothetical situations that talk about dealing with candidates, having candidate forums. But also, I will submit to the committee a much broader document that's also available on the IRS website. So thank you very much.
Thank you. We'll start with Delegate Howard and then Delegate Weigel.
Thank you, Madam Chair. It seems to me, though, that this bill would circumvent. Let me back up. So in the fiscal policy under current law, page 3, under the Johnson Amendment, it speaks specifically to the constitutionality prohibition being challenged as recently as last year, July 2025, and that both parties consented judgment. The parties agreed that the Johnson Amendment does not prohibit speech concerning electoral politics and religious services, and proposed a settlement agreement which, if approved by the court, would permanently enjoin the IRS from enforcing the Johnson Amendment against the plaintiffs based on such speech. So wouldn't this bill be superseding and basically circumventing a court ruling, at least as far as an agreement on both parties concerning freedom of speech of politics and religious services?
To respond to that, first, that after July, that judge has still not ruled. I mean, we're awaiting a ruling on that consent decree. It has been contested by amicus briefs filed by numerous national organizations, arguing that it itself violates the law, is an improper interpretation. I would note in that case that until July of 2025, the Justice Department had been defending the statute as it had for 70 years. What our bill would do, contingent on a federal change coming into effect, we would say that in Maryland, while we can't change your federal tax status, Maryland would not subsidize political activity by charities and churches through the exemption from state income, corporate income tax, state sales tax, and state property tax. Their enforcement is laid out in the bill. That has been amended to remove some of the more burdensome problems that were identified at the earlier hearing. For example, the bill as it's in there would say the revocation period would be 2 years. In the amendments, which are, I think, were just finalized about 10 minutes before this hearing started, that's going to change to that any revocation would end as soon as the parties come to a settlement agreement over whether there was a violation or not.
The in-state parties, so the religious institution, let's say, and the state, let's say the OIG's office or the AG's office.
Yes.
Okay. But this would still supersede even the agreed party, the agreement by parties at the federal level.
Well, if that occurs and the
well, it
IRS,
has occurred.
If that occurs, well, they have agreed, and that's, as I said, that's being contested.
It says it right there that they've agreed that political speech
They proposed a consent order to the court. The judge has not accepted that.
So we would be circumventing
our first hope,
potentially a court ruling that we don't even know the outcome of.
We're not doing anything until they act. The bill is contingent.
So we would be
doesn't take
potentially
effect.
Circumventing a court ruling we don't even know the outcome of. Well,
all we're doing is putting in place
you're
kind of a
shaking your
safety
head.
net.
How would we not be doing that?
Mr. Bogdan is saying the bill says that it is contingent, dependent upon a ruling.
So if we don't get the ruling that we like, whether we like this bill, my feelings all aside on this bill, whatever it means, if we as the state decide we don't get the ruling we like, then this bill goes into effect. And we would supersede the court ruling.
We are urging you to make that the public policy in Maryland, that even if the federal IRS decides to allow tax-deductible contributions to flood our elections through charities and churches, that Maryland will still try to enforce some limitation on that by a penalty of, you're not required to subsidize speech with taxpayer money, essentially, is the logic behind the federal rule, or has been the logic behind the federal rule. We're saying Maryland shouldn't subsidize that.
How do you square this with
tax
corporations
exemptions.
having freedom of speech under the Obama administration?
Excuse me?
How do you square this based on corporations being allowed freedom of speech privileges under the Obama administration?
I believe that was under a decision of the Supreme Court of the United States.
But that was based on a court ruling, and that's what we're looking at here, right?
That ruling, we believe, did not affect the validity of the language in the Internal Revenue Code regarding taxpayer subsidies. We believe that still is valid law. The amicus that were filed in the case in Texas all believe that was current law. The effect of the Texas case would also, we believe, create a different unbalance between churches and other charities. And that other charities would, we think that would start unraveling the whole system of regulation of C3s, frankly.
This could still be challenged by a higher court, right?
Yes, it could.
Okay. Even if you got the ruling that you're not in favor of based on this legislation, it could still be challenged at a higher court, right?
That's possible, and I think the rule, if they get, if we, that ruling would be taken up, yes. And our bill would not take effect until there's some decision.
Okay, thank you.
Thank you, Madam Chair. I'm just trying to understand the civil penalties and the appeal process and all that. So the Secretary of State or the AG's office can issue civil penalties not exceeding $5,000 per violation.
That's where one of the amendments is. The amendment is written to reduce that to $1,000. And the amendments will lay out, it's almost clear in the bill as it sits, that the first step will always be an offer of mediation to resolve the problem. Unintentional, didn't realize it was not a violation. That can be followed by a civil penalty up to $1,000.
So the Secretary of State or the AG's office determines whether or not they're in violation.
Right. The Secretary of State's office has an embedded Attorney General.
So they could basically be weaponized to go after certain nonprofits if they don't like their position on stuff?
Anything they do would be subject to an administrative hearing and follow the Administrative Procedures Act to go up to circuit court in the event there's a disagreement where somebody feels it's not impartial enforcement.
So your appeals process, it says they can request a hearing with the Secretary of State. That's the same person who just found them guilty of violating this act.
That much follows the pattern we have right now in law on charitable registration issues and about illegal solicitation.
So the process is the Secretary of State finds a nonprofit guilty of violation. They give them a civil penalty of $1,000, and then they have the right to appeal to the Secretary of State? Because I'm confused. It says within 30 days after receiving written notice, they shall revoke their income tax exemption, sales and use tax exemption, and property tax exemption. So it doesn't say may, it says shall. So if you get a notice within 30 days, you're going to have your certificates revoked. Is that correct?
No, I don't believe that's correct. After 30 days, we give you 30 days to request a hearing. That follows possibly a mediation effort, which we believe is the preferred route to deal with these situations.
So if you do a mediation, you don't resolve within 30 days, the way I read it, you're just automatically going to have your certificates.
No. And
is that an amendment?
And revocation is a may. That is discretionary.
No, it's not. It's on page.
If
it's right here on line page 8, line 26. It says the director shall revoke the charitable organization's income tax exemption, sales and use tax exemption, and property tax exemption. It doesn't say may. It says shall.
That's after notice from the Secretary of State, and whether or not to issue that notice is a may. That's discretionary. That section.
I don't see a may, but I guess I'll take sorry for that.
I mean, if we've missed that, then we would fix that in a subsequent amendment. I mean, the effort here, and I mean, we've worked closely with the Secretary of State's office on enforcement issues over the years. We've helped strengthen the Secretary of State's office. We created back in 2014 a special fund, enforcement fund, paid for by increases in the registration fees. Because the Secretary of State's office primary goal is compliance.
So if the nonprofit doesn't come to an agreement with the Secretary of State or the AG, they file an appeal with the court system?
If that's the way the Administrative Procedures Act works. Currently under the Secretary of State statute and as referenced, I think in section G2 of the new section 623.
And would they, at that point, already had their exemptions revoked?
No.
So it would be stayed based on the appeal?
Yes.
All right, I'm not sure the language is clear on that, but thank you.
Thank you, Madam Chair. So to the gentleman to the left, I didn't pay attention to the panel. What is your name and what is your role in the?
My name's Henry Bogdan. I'm the policy director at Maryland Nonprofits.
And what is Maryland Nonprofits? Just explain a little bit about the business.
Maryland Nonprofits is a statewide organization of close to 2,000 nonprofit organizations. We try to represent the interest here of the nonprofit community. We do primarily training, education for nonprofits, but we also try to represent their general interest in Annapolis.
Do you represent the interests of like Maryland Right to Life?
I'm sorry?
Do you represent the interests of Maryland Right to Life?
If they are a nonprofit organization, we represent the well-being of 41,000 nonprofits across the state. So we're a statewide association?
Let me ask this a different way. Do you represent all nonprofits in the state of Maryland?
We try to represent the broad interests of that affect nonprofits as their status as nonprofits.
Right, and whether they're members of our organization or not, we represent them.
This does not mean that we try to represent everybody's specific policy interests. That's well beyond our capacity.
Well, I mean, but is it safe to say that you're here representing the interests of this through an association or a group, but that not all nonprofits are going to agree with your testimony?
That would be true. Not all will agree.
Okay, that's what I was asking. So how does this start? And I mean this with all sincerity. Is this complaint-based? Is somebody complaining to the Secretary of State or Attorney General, or is this happening through government going around looking for violations, willful violations, et cetera?
Well, the pattern under as the law currently exists with the Internal Revenue Service is essentially complaint-based.
It's complaint-based. So
yes.
Who do they complain to in the state of Maryland under this bill?
Under this bill, they would complain to the Secretary of State or Attorney General.
And who could complain?
The public, they feel an organization is breaking the law.
All right, and so any of our 6 million plus or minus citizens in the state of Maryland could file a complaint against a nonprofit. What happens after that complaint is filed?
Any of them can do that today.
No, I understand. Don't misunderstand. I'm trying to understand how the bill works. So one of our 6 million citizens, sir, one of our 6 million citizens files a complaint with who again?
I can't speak for the Secretary of State or Attorney General. My belief would be that likely the way this would play out, this is hypothetical, that they would decide whether or not they feel that complaint is worthy of examination.
Who's they?
The Secretary of State and Attorney General.
And so both Secretary of State and Attorney General?
The Secretary of State, in terms of enforcement, has its own enforcement people, and it has an embedded Attorney General who work
yes,
in the same
I understand
office.
that. Okay, so this then goes to the Secretary of State. It doesn't go to the Attorney General. The Secretary of State has Attorney General representation in their role. Okay, all right. And so they and they alone will conclude whether or not there is a violation?
Well, they would decide whether to proceed with an examination of the circumstances. They would then make the decision whether or not they have reason to believe there is a violation.
Okay, and so my next question then falls to, now that I understand how a complaint can happen, which seems fairly broad and easy to throw a violation, how often do you think a violation, a complaint, will lead to a violation and therefore this mediation?
I wouldn't want to speculate on that, sir.
Okay, do you think there'd be any political exercise in play that would allow this complaint to be political in its nature from the beginning? I don't like this nonprofit, therefore I'm going to complain that what they're doing is not right, and I need the Secretary of State to do something about it.
Well, our concern is articulated in our testimony is that by changing the law from the current practice, the limitation in the Johnson Amendment, you're opening up the process, you're politicizing everyone's tax exemption.
I'm saying my concern is that you are politicizing the entire process by allowing a complaint procedure like this under this kind of bill to allow any complaint that leads to an enforcement action for political purposes.
It's the same circumstances, sir, exist with respect to an allegation of improper solicitation or misuse of charitable money. And we would point out,
but we're not talking about money now. We're talking about
penalty provisions and the enforcement.
We're not talking about money,
provisions
sir.
here.
We're talking about First Amendment rights and the ability of a nonprofit to do what they do under the law. The mediation, it says here that 15 days, a charitable organization that receives this violation from one of our 6 million citizens that says, hey, these nonprofits are doing something wrong, that a charitable organization must accept an offer for mediation within 15 days. Why must accept? Why would a nonprofit must accept the course of a mediation when perhaps it's better for them just to go right to the courts?
Because we believe that we should focus on trying to have compliance and understanding of the rules. And so that's why mediation, one of the amendments says not that an offer, it may be an offer of mediation. All notices would include a notice, rather would include an offer of mediation, because we want to stress mediation to get compliance rather than penalizing folks.
If I were on a nonprofit and I was on the receiving end of a violation, I'd rather see it in court. Why not just go to the court?
You would have that option.
No. Under the bill, I must sit down and have mediation.
You can decide not to come to mediation.
It says that I must accept offer for mediation.
No, it says they have to offer mediation.
The fiscal note, and we're running into the same problem that Delegate Weibel's having here. I'm reading the fiscal note. It says a charitable organization that receives a violation notice must accept an offer for mediation within 15 days.
I can only say the fiscal note was written before a slew of amendments have been drafted for the bill.
My last question, and it's a sincere one. I hope you take all these questions with a degree of sincerity, that I'm concerned about a bill like this, and that First Amendment rights matter. Most of the testimony that I'm seeing here from people that oppose this are organizations that are nonprofits and/or are representing the interests of nonprofits that are very concerned about their First Amendment rights being violated. Can you resonate with that concern?
We are very strongly supportive of the First Amendment rights of organizations and individuals. We believe, as I said, and others have said here, this bill preserves any authority, any ability to engage the public and legislators on policy matters. All the bill does is continue, in effect in Maryland, the policy that electioneering, as opposed to just policy advocacy, can't be done by people who still receive state tax exemptions from the income tax, sales tax, and property tax.
Thank you.
Thank you, Mr. Bogdan.
The sponsor of the bill, thank you for bringing the bill. I hope you take my questions with a degree of sincerity for some concerns I have with why it's here.
I appreciate that.
Thank you. Thank you, Delegate Adams. Thank you, Mr. Bogdan. Delegate Pippy.
Thank you. Thank you, Madam Chair. Delegate, good to see you. Couple questions. So both the Office of the Attorney General and the Secretary of State, in reading their letters of info, seem to be concerned with just the executing of this bill. So if you could maybe touch on that, and their concern seems to be around the fact that this would require a significant amount of enforcement, things that they're not currently doing. The Secretary mentioned in her letter that these people aren't even members of what I enforce currently, that these people aren't even paying into the fees or whatever. So I don't know if you could address just their concerns related to the enforcement of this bill should it pass.
If this bill takes effect and they experience the need for additional staff, and I believe the estimate was something like $200,000, I believe we would advocate with them to raise certain fees that are already paid on the books. We raised those fees back in 2014, which allowed them to get a computer system, allowed them to hire a full-time attorney general or pay for a full-time attorney general. And our position would be to support another increase in that increment fee, which would have to be a very small increment, frankly. That fee now raises, I think, about $1.4 million a year. So it would take just a slight increase in that fee, just as an example of how that would be dealt with. But we're not there where we have the problem yet.
And you said we raise this, you raise those fees?
The legislature raised this fees at request and bill legislation we submitted together with the Secretary of State's office and the Attorney General's office.
Okay, so the legislature raised the fees.
The legislature raised those fees.
Okay. So then the second part, looking at the fiscal note, it says that, ironically, that local income tax and property tax revenues increase beginning as early as FY 2026 to the extent tax exemptions are revoked under the bill. I know that we have some fiscal challenges in our state, but is that like the underlying purpose of this bill, to like raise revenue?
Sure. Our hope, I think it's the hope of all of us sitting at the table, is this bill would never go into effect. We will continue to work with partners at the national level to try to preserve the Johnson Amendment as it exists today. If it goes into effect, we would then have to deal with those circumstances. We would also hope that there have to be no revocations, that organizations would comply, which is why we try to stress compliance. It's why the amendments are strengthening the stress on compliance and mediation rather than penalizing.
Okay. So my last question, and I'll preface it with what the colleague to my left said about, I hope you appreciate this question and its sincerity, and this question is for the sponsor, Mr. Rosenberg. So, Delegate, we've seen a couple bills come into this committee where they're like, if this happens over here, then this bill explodes, right? This bill is a little different. This one's like, if the courts do this, then we do that. And so, Delegate, you've been a delegate for a long time. I mean, is this the right way to pass legislation? I mean, how many bills do we pass to where if a completely separate and distinct entity somewhere else does something, then we do something? I mean,
we are facing an unprecedented effort at the federal level to change existing law. And we can wait until the law has been changed, and then we wait until the bill takes effect at the next session, or we can act now. And in this instance, we are acting, this bill, if it were to become law, preserves the status quo in Maryland regarding political activities by a nonprofit. So I don't see why there would be this increase in enforcement.
The only thing is, I hear it frequently, and again, this all due respect, we hear unprecedented, we hear Trump, we hear ICE, all these bingo phrases that they keep coming in here to sway people into making knee-jerk reactions. The bigger question is legislatively, and look, you have legal history and certainly a respected individual in that right. Is it good legislative practice to pass bills? If so-and-so does this, then we do that. I mean, is that how you go about legislating? I mean, is that appropriate in your experience?
Well, I would submit, and we just politically disagree, we are facing an unprecedented situation in terms of changes being made at the federal level. I mean, the Supreme Court is undoing existing case law in the Chevron.
I mean, but it's the Supreme Court. The Supreme Court is the Supreme Court. It's the supreme law of the land.
But
so are you saying that because the Supreme Court, who by all legal right has a right to do what they're doing, because you and I take the same oath as lawyers, right? It's the Supreme Court, it's the supreme law of the land. Because you don't like what they're doing, we're going to pass bills here hypothetically in response if they do something? I just want to confirm.
We can provide more protection. I testified yesterday on a bill reinstating the compelling state interest test for free exercise claims. And I don't know for sure, but many of the ministers, the clergy who spoke in favor of the bill were perhaps among the people who were opposing this bill. But the Supreme Court said we're no longer going to use the compelling state interest test in a free exercise case. That makes it tougher for somebody to win an exemption from a generally applicable law under the free exercise portion of the First Amendment. We have the states have the power to provide greater protection under any provision of the Constitution than federal statute or a court decision does. And states have enacted Religious Freedom Restoration Acts. So we have that power. We chose not to exercise it on religious freedom, but clearly the states can give more authority, can't limit the authority provided under federal law, but can extend it. There's no question about that.
And then you also have this as an emergency bill, right? Okay. All right. Thank you. I appreciate you answering the questions. Thank you, Madam Chair.
Delegate Roberts.
Thank you, Madam Chair. I guess my question is for the bill sponsor. Do you know how many other states have done a bill like this, or can you name some of them?
I need to defer to my colleagues.
New York adopted the law in response, excuse me. The state of New York amended the language of the Johnson Amendment into their definition of charitable in their tax laws, I believe in 2018 during the first Trump administration. That was in response to an executive order that didn't actually change any of the rules. After that, I believe we may be the next state. We have been contacted by other states regarding how we're proceeding. I defer to the National Council. I mean, I don't believe no one else has passed a bill yet like this other than the state of New York.
That's right. Yeah, if I could speak to that. So there are other states that are watching what's happening in Maryland, and we've had some private conversations with several states that are interested in doing something similar. And I think their concern is just that one that's already been articulated about using a public tax subsidy to subsidize private political speech, essentially, because the 501c3, that's the only kind of nonprofit that allows you to do that. And so I think a lot of states are looking at that from sort of an election integrity standpoint. And, trying to look at this as let's not take a public tax subsidy and, hive that off as something that gets to be used for private purposes.
Okay, all right. Thank you. Thank you, Madam Chair.
Seeing no further questions, thank you, Delegate Rosenberg and your panel for your testimony.
Thank you.
We'll now move on to the opposition. We have Lawrence Davis, Jeffrey Trimbath.
Madam Chair, Madam Vice Chair, members of the committee, my name is Jeff Trimbath. I'm the president of the Maryland Family Institute here in strong opposition to HB 514. For most churches, engagement with their people runs from baptism to burial. Political campaigns sit so low on the totem pole of pastoral concern that they are at best a periodic topic compared with worship, sacraments, and works of mercy. When a pastor or priest does speak about candidates or elections, it is as a necessary extension of these primary duties, helping their parishioners form their consciences before God about loving their neighbors well. For many faithful Marylanders, voting is an act of conscience, formed through one-on-one conversations, around dinner tables, in Sunday school classes, and yes, periodically from the pulpit in official statements as a ministry. At the same time, religious nonprofits do work in this state that wouldn't get done without them, educating children, feeding the hungry, and housing the homeless. HB 514 tells those same organizations, you may feed, teach, and heal, but if you connect your faith convictions to voting, if you speak on behalf of or in opposition to someone on the ballot, the state can strip your church, your parsonage, and your school of their income tax deduction, sales tax exemption, and even their property tax exemption. The state can fine you up to $73,000 a year. The state can force you to register with them and take an oath with them to not engage in these things. And the state can force you to submit to its policing of sermons, newsletters, and other congregational correspondence. Frankly, government has no business telling what we can say from our pulpits, in our classrooms, or in our counseling rooms. And for these reasons, we think HB 514 is a very bad idea. Thank you.
Good afternoon, Madam Chair, Vice Chair, members of the committee. My name is Tony Davis. I am an attorney, and I am the Legal and Legislative Chair of the Maryland Christian Chamber of Commerce. And we are asking for an unfavorable report on HB 514. You heard from the sponsor, and you also heard from the panel that this particular bill, the purpose of it is to maintain the status quo. That statement alone shows you that this bill is unnecessary. In addition to that, they said that this bill will put pressure on, if you don't pass this bill, that pressure will be put on nonprofits to do certain things. And I can tell you that that statement is flawed. But I can tell you that here's what the result would be. If you pass this bill, you will muzzle people because they won't know what to say. If you have an opposing opinion, they're going to be afraid of fines and they're going to be afraid of losing their status. And we can see that in page 5, line 25, where it talks about campaigning on behalf of or opposing another candidate. And let's get to the status quo. We know that even within this General Assembly, we have pastors. Some of us have campaigned at churches. Some of us have members of our churches who are running for political office. And we've had people speak against the current president because they don't like his demeanor. But the converse should also be true. We should not muzzle those who may want to support the president. We've had many cases go to the Supreme Court because of equal protection, free speech, and an establishment clause. We can act like that's clear, cut, and dry, but it's not. So what they're saying is no litigation here, but I can tell you that this bill is not right because nothing has happened yet. But what would be right is if you pass this bill, this state will be involved in some unnecessary and costly litigation. So I say let's avoid all of that and oppose this particular bill. Thank you.
Thank you, Mr. Davis, Mr. Trimbath. Seeing no questions, thank you very much for your testimony this afternoon. We do have a virtual unfavorable, Mr. Paul Arkand.
All right, can you hear me okay?
Yes.
Okay. Thank you, Madam Chair and members of the committee, and I really appreciate your spirit, Madam Chair. I've enjoyed this committee meeting today, and I like how you conduct business there. My name is Pastor Paul Arkand, and I serve as the pastor of the Lighthouse Baptist Church in Severna Park, Maryland. And yesterday, I was able to commend Delegate Rosenberg. We were on the same table as we vigorously defended religious liberty in another matter. And I appreciated that. But today, I must respectfully oppose and ask for an unfavorable report on HB 514. I believe the bill may be intended as a safeguard, but it certainly creates a structure that I don't believe could, I believe it will have a chilling effect on pastors and churches across the state of Maryland. And the concern is not partisan politics, but it is conscience. Pastors have got to remain free to speak clearly about moral issues, to rebuke wrongdoing, and at times to commend leaders where they act righteously, of course. Scripture shows spiritual leaders doing both. And if a pastor has to pause and wonder whether acknowledging a public servant's courage or criticizing a policy might later be interpreted as intervention, it's going to cause hesitation. That hesitation, I should say, chills speech. The threat of civil penalties as temporary loss of property tax. I mean, it's tens and tens of thousands of dollars. I've been in the situation. And so churches are not seeking to control elections, but I am saying that we need to have a free ability to speak without having penalties imposed upon us. I think I may have frozen here, but I don't want to run out of time. Thank you, Madam Chair.
Thank you, Pastor Arkand. Seeing no questions, thank you very much for your testimony. We have one more virtual, informational purposes. Michael Laurie.
Hi, good afternoon, Madam Chair, members of the committee. I'm just here to answer any questions if there are any. We appreciate the nonprofits. It is their special fund as well. And we get funds from $100 out of the $300 fund for the largest of the charities. I just wanted you to know that figure. There are 700 or 7,356 of those charities that supply the majority of our special fund, the nonprofit special fund. And I just wanted to make the committee aware of that. We're not asking for an increase in the rates. We just wanted the committee to be aware of where the funding comes from and here to answer questions.
And for the members who don't know Michael Laurie, he is with the Office of the Secretary of State. So if there are any questions for him, you got a compliment from Delegate Pippi, Michael, that you're great. But seeing no questions, thank you very much for being here with us, Michael.
Thank you.
No other witnesses. That concludes the bill hearing on House Bill 514. That concludes our bill hearings for the day. Members, yes, Delegate Ampry.
I just wanted to, go ahead, I was wondering, I could have a moment to say something after you're done.
Oh, sure. So yes, that concludes our bill hearings for the day. I do have a couple announcements that don't require being on camera. So thank you. Housing Subcommittee meets at 3 o'clock. Okay, so Housing